Introduce our first session, which will be on accountability. We really want this session to kind of delve into the complexities of the Syrian conflict. And so our esteemed panelists will shed some light on the critical importance of holding perpetrators of atrocities accountable. And we want to talk through, how to foster justice and ensure the protection of human rights within Syria and other. So from examining these legal frameworks to explore international responses, this discussion really just aims to contribute to the ongoing discourse on accountability and pave the way for more meaningful action towards justice. So it's my honor to introduce our moderator, Dr. Paul Williams. Dr. Paul Williams holds the Rebecca I. Grazier Professorship in Law and International Relations at American University, where he teaches in the School of International Service at the Washington College of Law. Dr. Williams is also the co-founder of the Public International Law and Policy Group, or PILPG, which is a pro bono law firm providing legal assistance to states and governments involved in peace negotiations, post-conflict constitution drafting, and the persecution of war criminals. As a world-renowned peace negotiation lawyer, Dr. Williams has assisted in over 24 parties in major international peace negotiations and has advised numerous parties on the drafting and implementation of post-conflict constitutions. Several of Dr. Williams' pro bono government clients throughout the world joined together to nominate him for the Nobel Peace Prize, and we are very excited to have him as the moderator for this event. So Dr. Williams, Professor Sterio, please come and join us and we can take this topic off.
Thank you, Jude. Well, Jude, thank you for those very kind words of introduction. And I just wanted to echo Dr. Bakir's observations that accountability is crucial and necessary, both for any durable peace in Syria, as well as for victim catharsis and victim healing. It's complicated to figure out how to weave justice into a conflict situation, as well as a post-conflict situation. So I'm very excited that today we have a superstar panel to discuss, both here in Washington, D.C. and zooming in from abroad, to discuss this question of how does one bring accountability to the conflict in Syria. Let me go ahead and jump in and introduce our three panelists. We have Professor Milena Sterio sitting with me here in Washington, D.C. Milena is the distinguished professor at Cleveland State University College of Law, and she also holds an endowed chair in international law at the university. She's a leading expert on international law, criminal law, human rights, universal jurisdiction, and the prosecution of atrocity crimes. I'm also proud to say that she's a managing director at the Public International Law and Policy Group as well. And she heads up our thought, being the smartest person at PILPG, she heads up our thought leadership programming at PILPG. She's also a permanent editor for the International Law Girls blog and a former Fulbright scholar. She's authored over half a dozen books and numerous law review articles, including a book that she, Mike Sharp, and I co-authored on the Syrian conflict's impact on international law, published by Cambridge University Press. So Milena, welcome. We're excited to have you here.
Thank you. It's a pleasure to be here.
Next, I would like to introduce Fadel AbdulGhany. Fadel is the founder and executive director of the Syrian Network for Human Rights, which he established in 2011. He holds a master's degree in international law from the Montfort University in Leicester, United Kingdom, and in recognition of his tireless efforts for promoting human rights and human rights advocacy via the Syrian Network for Human Rights, he was awarded the prestigious 2023 Franco-German Prize for Human Rights. Fadel, welcome to the panel, and congratulations.
Thank you so much for having me.
We also have Ibrahim Olabi joining us today. Ibrahim is a barrister who specializes in international law, knowledge, and experience with a focus on the Middle East. He works both on international legal cases and public advocacy and lobbying, as well as sharing his knowledge, thoughts, and ideas on policy matters, specifically related to questions of justice linked to the region. Ibrahim, you've seen him many times with his regular media appearances. If you've been channel surfing BBC, CNN, The Guardian, Financial Times, Al Jazeera, and Al Arabia, he's a frequent commentator on these issues. Now, today's discussion will be 60 minutes, followed by a Q&A from the in-person audience and the remote audience. I did want to make one programming note that we expect around 11:45. Senator Shaheen will join us and provide some remarks. So we'll pause the panel as appropriate at that time for the senator to listen to her remarks. Well, let's kick this off now. We have a series of questions. The first is two questions on the legal framework for accountability. And I'm going to turn to you, Ibrahim, for the first question. It's a compound question. I couldn't resist. Jude and I came up with these questions, and so we rolled 3 or 4 questions into each. So Ibrahim, if you could share with us your knowledge and experience on what legal mechanisms exist for holding perpetrators of atrocities in Syria accountable under international law. How can these mechanisms be effectively utilized to ensure justice for victims? And what challenges and limitations of existing legal frameworks exist in pursuing accountability in Syria? And after your thoughts, I'll turn to Milena with an additional question. Ibrahim, over to you.
Thank you for having me, and thank you for the questions. I mean, the beauty of compound questions is that then I get to answer them in whichever order that I want, and perhaps the challenges that we have in accountability help really set the scene of what we have now. But first, perhaps really just to kind of in the situation that we are in Syria, which is still very much plagued with impunity, perhaps it's important to really define accountability, how different people see it. And I think it's important to really note that for many, criminal accountability is absolutely an essential part of accountability, the idea of perpetrators, being seen behind bars, arrest warrants, and so on. But the process itself being seen as part of accountability, the resistance of victims and survivors groups when perpetrators try to silence them is a form of accountability. The idea of naming and shaming and writing history and ensuring that the narrative still holds at a time where perpetrators are trying to kind of control the narrative and control history is a form of accountability. And so anything that kind of creates a negative consequence for the perpetrators, I personally see it as a form of accountability in that sense. Obviously, some things cause more negative consequences, hold them to account more than others, and so it's a spectrum in that sense. And so the kind of framework that we have in Syria really begins very early on with accountability by fact-finding, by ensuring that we know the facts, we know what's happening on the ground, trying to kind of ensure that the crimes are being documented in that sense. And for that, since 2011, we had the UN Commission of Inquiry that was established by the Human Rights Council, which up until today has been issuing report after report, and still has the mandate from the Human Rights Council to conduct such documentation. You fast forward a couple of years on, and there was an attempt to refer Syria to the International Criminal Court that was double vetoed in I think 2014 it was. And it was the US actually put forward a draft resolution amongst other countries, and it was vetoed by Russia and China. And this would be was a turning point in the accountability landscape, because what happened then is that the permanent court that was international court, criminal court that was created in order to deal with these crimes was now very clearly blocked. And now and then the whole kind of landscape changed, and it changed in towards multiple ways. One, you had organizations and states looking to create organizations that could do as far as they can, right before or right until actually being a court. And so in 2016, we had the General Assembly create the IIIM mechanism, which is the semi-prosecutorial body by the UN, which is unprecedented, right? It has never been created before, and actually set the scene for a similar mechanism for Myanmar later on. So Syria actually helped shape the accountability landscape by saying, well, if courts are blocked, if international courts are blocked, then we will do, as the closest thing that we can, the next best thing from a criminal justice accountability perspective, and we will not just document cases, but we'll actually build cases pending at court. So this kind of IIIM mechanism was kind of, I think, phenomenal in the way that it shaped the landscape, its engagement with civil society, with victim groups, with building the cases, assisting courts, and so on. What then happened is, because international criminal justice was blocked, a lot of organizations, victims groups, Syrian organizations, international organizations started turning towards domestic universal jurisdiction cases in Germany, in France, in Spain, in the United Kingdom, in Belgium, in Sweden. So wherever, there was either a perpetrator present or the laws allowed to kind of move without the perpetrator being present, you saw a serious utilization of these efforts in that sense, with both arrest warrants being issued, trials in absentia, and actually trials for those who were in the country of that triggered the prosecutions. So these kind of remain individual cases in different parts of mainly Europe. And the reason, that they were kind of moving on is because, victims and survivors and organizations that support them kept pushing in that sense. Now, while they and while the kind of these are individual criminal responsibility, what we've seen is that a lot of the charges against them go beyond the individual in question. They were about charged with crimes against humanity, which by their very nature means that this person was part of a system in a way, or engaged in kind of widespread, and could not have done it on their own. And so when we've seen the judgment come out of Germany, we've seen that, yes, it was against one or two individuals, but what the court said, it acknowledged the narrative around the crimes around it, which showed that this was a wider regime policy, but these two people are the ones that I have jurisdiction over. So these are the kind of universal jurisdiction cases that we've seen. And then in 2019, what has happened is that another initiative has started, because, again, torture was blocked from the ICC, is that the Netherlands and Canada decided to take Syria to the International Court of Justice over the Torture Convention, which in this sense is, quote unquote, a civil matter, in the sense that it's not of a criminal nature. It's an interstate dispute invoking the responsibility of Syria as a state, which has a lot of benefits, albeit not being a criminal process. And we've seen that triggered since 2019, with the first hearings happening on the 10th of October, unfortunately, which meant that they were kind of overshadowed with the events of the 7th of October afterwards. And then and then the court actually ruling against Syria on November 16th. And here what we've seen again is, because the criminal justice was blocked, state responsibility was invoked by the Netherlands and Canada against Syria for mass torture from at least, quote unquote, at least 2011, before the International kind of Court of Justice in that sense. So these are the kind of nature that this is the landscape as we see it. Some domestic criminal cases, some semi-prosecutorial mechanisms, matters happening at the ICJ. And then we see other demands. There are demands for chemical weapons tribunals. There are demands for a wider Syria tribunals, and we've seen pushes here and there, including in the US, for a wider accountability scene. Now, for these to be effective, linking to your second point, I think personally, two things need to happen. One, they need to be able to collaborate with each other, share information, how the IIIM can assist the Torture Convention, how the Torture Convention trial can learn from Koblenz in terms of the evidence, how one prosecutor could benefit from the experience of the other prosecutor, and so on. So kind of a complementarity amongst them in order to kind of avoid repetition. And then the other point is an issue of strategy, right? Is where are we kind of focused in that in you know, where is it that we're going in the strategic litigation side of things. And then the third thing is the amplification of it, because obviously we have a lot of fatigue in terms of, you know, we want to know of one case happening or another case happening, but there's been a lot that's been going on in terms of the accountability scene, and there's not enough limelight being kind of shed on it strategically to see how things kind of are moving on. To give an example, I think it's worthwhile studying the case study of the French arrest warrants against Bashar al-Assad himself, his brother, and two other senior officials for the alleged use of chemical weapons, where there is evidence pointing to their involvement. And so, yes, that arrest warrant against Bashar himself as a sitting head of state is being now appealed in France. But that in itself did not make the news that we thought it would make. Regardless of the question of immunities aside, there is a fact that French independent judiciary were able to kind of pinpoint towards Assad himself for complicity in the use of chemical weapons as sitting head of state, which is in its form kind of phenomenal in that sense. So I think there is a fatigue linking to the final point. There is fatigue. There is this idea of what's the point. There is this idea of disenfranchisement within international law as it is. And I think that's one of the biggest challenges. But I think that challenge, you know, if we give up and we don't really focus on them and we don't shed light strategically on those cases, we are only serving the perpetrators in that sense. So there is an ecosystem. There are different parts, moving parts of it. There are things that are moving. In the last briefing of the IIIM before the General Assembly a few days ago, the IIIM noted, you know, I think more, is it 70 or 80 cases that they've assisted in that sense. So things are moving, but we're just not able to utilize them as much and shed light on them as much and be strategic about them.
Well, thank you, Ibrahim, for that tour de force survey of the various mechanisms that are being used to attempt to hold the perpetrators of atrocity crimes accountable for those crimes. I want to pick up and turn the microphone to Milena and pick up on one of the mechanisms that you highlighted, and that is universal jurisdiction. Now, Milena, as you know, there's been several universal jurisdiction cases filed regarding accountability for these atrocity crimes. And one such example, as mentioned by Ibrahim, is the French arrest warrant for Syrian President Assad, as well as others, for their complicity in war crimes and crimes against humanity. Can you walk us through what is universal jurisdiction? Why is it important? And what can we expect as an outcome?
Thanks for that question, Paul. Sorry. Let's see, I think this microphone is on. Thanks for the question, and it's such a pleasure to be here. Now, as Ibrahim very clearly outlined for us, some of the other international accountability mechanisms haven't been as effective in terms of bringing perpetrators to justice. So, for example, as Ibrahim outlined, the International Criminal Court has basically been deadlocked on Syria because of these Security Council vetoes by Russia and China, and we just haven't seen a tremendous amount of political appetite in the international community to create another type of a special international tribunal for Syria. So with that, we've been left with the possibility of having prosecutions of Syrian perpetrators in the courts of third countries under the principle of universal jurisdiction. So what is universal jurisdiction? Universal jurisdiction is a basis of extraterritorial jurisdiction, which requires no nexus, no link between the perpetrator or the crime and the prosecuting forum. Now, universal jurisdiction only extends to the most heinous crimes, such as genocide, war crimes, crimes against humanity, torture, slavery, piracy. But the main feature, again, is the fact that you don't need to establish a link or a nexus between the perpetrator of the crime and the prosecuting community, which means that courts in countries such as Germany, France, Sweden, Spain, Switzerland have been able to open investigations and to actually have prosecutions against Syrian perpetrators of atrocities that took place in Syria. So here, let me just mention a couple of different cases. Ibrahim already mentioned this, and I think, Paul, you mentioned this in your intro as well. There have been two cases in Germany where German courts have actually, prosecuted and successfully convicted perpetrators of atrocities for crimes that they committed in Syria under the German version of universal jurisdiction under their domestic law. Germany has a very expansive universal jurisdiction law, which allows for those types of prosecutions. But I would say most interestingly, there have been cases in France where French courts have utilized universal jurisdiction to also investigate and prosecute Syrian perpetrators of atrocities. And in the French cases, we've actually seen developments in the French national law as a result of these cases. So Ibrahim already mentioned the November 16, 2023 arrest warrants that have been issued by a French judge against Assad, as well as a couple of other Syrian high-level perpetrators of atrocities for their complicity in acts of war crimes and crimes against humanity. That is obviously extremely significant, as Ibrahim mentioned, because it potentially implicates the prosecution of a sitting head of state. We'll see what happens to that. Unfortunately, there's precedent from the International Court of Justice, which holds that sitting heads of state are immune from prosecution in the national courts of other countries, but we will see how the French case unfolds. But even before the November 16 case, there were two other cases in the French courts called Chaban and Neymar, where the French Court of Cassation, which is the equivalent of their Supreme Court, decided back in May of 2023 that these cases could go forward despite restrictions in French law that had existed until that point. So one of those restrictions required so-called dual criminality, that the acts that these individuals are being prosecuted for in France also be criminalized in Syria. And these two defendants had argued that acts of crimes against humanity or war crimes weren't really criminalized under Syrian national law. They're criminalized under French law, but that under this dual criminality requirement, the prosecutions could not go forward. And the French Court of Cassation said, no, it suffices that these acts are actually criminalized under Syrian law as acts of murder or torture. They don't have to exist formally as crimes against humanity or war crimes. And so the French Court of Cassation allowed the cases to go forward. In addition, the French law had required that the offender be habitually present in France, and the French Court of Cassation reinterpreted that requirement to say some type of a link to France is enough. The person doesn't actually have to be like fully domiciled in France. And so these two cases are extremely significant because they demonstrate that basically national law can evolve in order to allow for these types of prosecutions. Now, in both the French and the German case, what's also significant, and Ibrahim also touched upon this as well, is this need for collaboration, coordination. So what's been significant is that the IIIM, this mechanism that was created back in 2016 through the UN General Assembly to collect evidence and store and analyze evidence of crimes committed in Syria, the IIIM, its mandate is to support both national and domestic level prosecutions. And so we know that the IIIM has been able to work with the German and the French authorities to support those types of prosecutions. And in various other European cases, investigations, structural investigations that have already commenced, the IIIM is also able to support those. And on that note of collaboration, I would also mention that within Europe, within the European Union, within so-called Eurojust, there have been joint investigative task forces that have been created, which allow for that type of collaboration and evidence sharing among prosecutors and investigators from different European countries. And there have been these joint investigative task force teams focused on Syria, focused on some of these Syrian cases. And so it is extremely important that we've seen an appetite, a willingness on behalf of various European countries to utilize their investigative and prosecutorial teams to hopefully bring some measure of accountability to Syria, because on the international front, as of now, we haven't seen too much. Despite the International Court of Justice case, we haven't seen too much accountability at the international level. So I'll stop here because I know we'll return to some of these themes later on.
Well, thank you, Milena and Ibrahim, for giving us that very detailed framework for relevant mechanisms to hold individuals accountable for these atrocity crimes in Syria. I now want to turn to Fadel first and then back to Ibrahim to talk about the international response and cooperation. This has been touched on a little bit with universal jurisdiction and the IIIM and some of the other international mechanisms, but let's dive a little more deeply into this. Fadel, let me turn the microphone to you to have you walk us through what role the international organizations and states have played to date in promoting accountability in Syria. How can the international community enhance further collaboration and coordination to address impunity and to promote accountability? Fadel, over to you.
I need 2 days to answer this question. Thank you very much for my dear friend Bakr for organizing and hosting. Thanks for the esteemed attendance. I'm honored to be among you. Indeed, this is a broad question, and why it's need a long time. I will try as possible as I can to be even shorter than my colleague, because they highlight 2 mechanisms, so they make it a little bit easier, because actually, and it's worth to highlight the international community and institution what they did to Syria, but they are a lot actually. So starting from, and we at Syrian Network for Human Rights almost work with all of them in depth. We are providing and sharing material and data information with almost all of them. Some of them even exist for specific period. I can refer to the board of inquiry established by the General Assembly. They a lot of people, they don't aware about it, because this is a UN body investigate attacks against vital facilities in northwest Syria, and they worked for 1 year, and that's all. The committee is done. So the first, like I still remember, the first responded international organization to defend the right of Syrian people uprising was Human Rights Watch and Amnesty International. And really, over all of those years, they played fundamental roles, and up to now, in documenting and highlighting lots of violation. The second one actually is the High Commissioner. The High Commissioner is because it already exists before even the Commission of Inquiry. The Commission of Inquiry coming after. It's coming after when the conflict is extended. So the Human Rights Council established the Commission of Inquiry. But the High Commissioner, it exists and it's monitored the human rights situation in all around the world. Their key report and the most important report they launched was in September 2012. In this report, they accused the Syrian regime in committing crimes against humanity. So since September 2011, the third international committee is the Commission of Inquiry. And I believe it's the most critical body that contribute to the process of accountability. And they issued approximately 38 reports highlighting various types of violation and accusing also their mandate to determine the perpetrator. So they accused the Syrian regime in committing various types of crimes against humanity and war crimes. They accused Russia in committing war crimes and other also conflict party like SDF and opposition and Hayat Tahrir Sham and others. There is also the UNICEF. I don't want to forget their role, because also they are documenting the violation against children, and they are the main source of the General Secretary report, which is talking about the abuses against children in all around the world. There is the OCHA. OCHA, they played controversial role actually, especially the office in Damascus. So not all of the mechanism they are with us. So we need, and it's worth to make this assessment, but it's need. I'm trying as possible as we can based on our relation and with them to highlight their role. The OCHA actually, I have a lot of criticism against them, especially on the cross-border aid. Their legal office, I don't think that they are supportive or active in taking a decision to allow the aid to the UN aid to cross the international border, which is for sure help Russia to blackmail the UN and the donor countries. The fifth body is for sure the OPCW, and here I can recognize two stages in the OPCW role in Syria in the accountability. The first one before the IIT team, the identification team, the role of the IPCW was just to mention if the chemical weapons being used or not, which doesn't relative to us as a human rights. We need to know who committed this crime, not only the chemical weapons being used. That's the fact-find mission. That's okay, but who committed this? The IIT actually issued four reports, accused the regime in committing or in applying use of chemical weapons for 5 times, including the famous attack against Duma. There is also other mechanism. It's called the JIM. It's because it's a joint mechanism established based on the UN Security Council. This body is higher than the OPCW because it's established by resolution issued in August 2015, and it's combined from the UN and the OPCW. And also they accused the regime 3 times in using of chemical weapons. And all of the UN Security Council resolution mentioned, including the one who established the JIM, that if there is a use of chemical weapons, intervention under Chapter 7 shall be committed, which doesn't happen. And this resolution, and there is also an academic mistake, widespread. I don't know, but there is a thought that Security Council resolution need to be under Chapter 7 to be binding, which is mistaken. Lots of resolution, even if they didn't refer to Chapter 7 at all, they didn't mention, but it's binding because it's the language, because of the language. And that's other topic and other discussion in international law. So the next one is the universal jurisdiction. My 2 colleagues refer to, and I will emphasize what Ibrahim said. The verdict of Anwar Aslan mentioned clearly crimes against the humanity. This is the verdict. And the Dr. Ala in Frankfurt trial accused him in crimes against humanity, which cannot be committed by individual. This accusation against the system, against the regime itself, because it's systematic, widespread. Systematic, Anwar is a part from those, but it's accusation for the regime at the same time. The next one is actually the triple IM. Ibrahim also and the colleagues talk about it. I don't want here. I will jump. We have also I don't want to forget the ONGA, the General Assembly. The General Assembly actually it was with us. The General Assembly always with us. The Human Rights Council always with us. What is against us? The Security Council. Because of the veto. Russia used veto 16 times, arbitrary. I will come to this point. But ONGA is always voted, the majority voted beside us. The Human Rights Council is always voted with us. We issued 2 reports. We reviewed all the Human Rights Council resolution and the UNGA resolution. And here it's part of naming and shaming to see which state they voted against us and how many times. Can you imagine only 11 states voted beside the regime? So it's unlike what is maybe the regime propaganda and the Russia. And all of them are like similar to Russia, this China, Cuba, Venezuela, those Russia allies. And in the UN General Assembly resolution, it's always mentioned the Syrian regime violations and crimes against humanity in several types of violations in all of the UNGA resolution. And sometimes even they refer to an intensive figures to show the scale of this violation, like the recent resolution they mentioned, and they used our data. They mentioned the 132 disappeared person in Syria in the center detention. The final one, and why I intendedly, and this is, I think, the aim of the question, to come to the conclusion. The Security Council. So if we have everything, we have verdict, clearly accused the regime, or not accused now, it's more than accused, it's verdict, mentioned that the regime committed crimes against humanity. We have tons of documentation with highest standard, like the OPCW, the JIM report, it's amazing. We have Human Rights Watch, Amnesty International, UNGA resolution, all of those, the Human Rights Council resolution, which is 37 resolution, all of them, the vote beside us against the regime and his allies. But the Security Council is against us. So we are losing. Can you imagine when the first resolution issued by the Security Council? It's April 2012. So after more than 1 year from the uprising started, and that giving an indication of what is this council is doing. I described the Security Council in one of my articles that it's an obstacle to accountability and justice. Russia using the veto sometimes to prevent the entry of humanitarian aid for the people, Russia involved in displace those people in northwest Syria and in northeast Syria as well. So what I want to say after all of those mechanisms, which is unlikely what is the Syrian is saying that, okay, there is a failure in accountability. Yeah, that's right. But we cannot like hold this failure to those mechanisms, to the High Commissioner or to the community. They are doing same of us as a human rights organization. This is our limit. But we have, if there is no investment in a political level, in Security Council level, they didn't take measures, including military measures, because when crimes against humanity, it should be an intervention to halt those. And if the Security Council failed, the intervention should be taken out of the Security Council, similar what's happened in Bosnia. Final word here is accountability cannot be achieved if those authorities, mainly the main perpetrator is Assad regime, committed approximately 80% from the total violation, if he is still in power. So the impunity will remain. The main accountability tools is the political solution, is the transition toward democracy and human rights. then transitional justice transitional justice path will take place, and for sure the local trial and all of that is the victims and many other things. Thank you.
Thank you, Fadil, for covering in great detail the eclectic array of international mechanisms engaged and, quite frankly, their limited impact and helping to identify some of the obstacles which prevents the international community and international organizations from effectively responding. We're going to now turn to Ibrahim to further detail some of those political obstacles to pursuing accountability, but in particular, to help share with us his thoughts and ideas on how those obstacles might be overcome and how the international community, international institutions can more effectively seek to ensure accountability. Over to you, Ibrahim.
Thanks, Paul. My colleagues and I highlighted a little bit some of the obstacles. The veto power, as Fadel mentioned, is one of the things that I don't think can be circumvented in this case through the Security Council. But I think the only way to add more pressure on the Security Council when it comes to the Russian and Chinese veto is to try and do things outside that system, to the extent where that system said where it then becomes important for Russia to say, no, actually I'd rather achieve accountability through the Security Council rather than kind of outside it. And so we've seen the General Assembly when it moved and did the IIIM, that kind of caused a lot of countries that were blocking it, Russia, China, Iran is not on the council, but they spoke a couple of days ago and said they don't even recognize this mechanism, but it doesn't matter, it adds that kind of pressure. So I think what needs to happen first of all is more political pressure on Russia and China not to veto resolutions when it comes to kind of accountability. And that can happen in many ways, as I mentioned. The other point is, one of the ways that this could happen is to kind of really keep amplifying the evidence that we have that has nowhere to go in terms of criminal justice, that the system is being burdened, that we don't have an outlet, that we need to fight, we have the evidence, but for a court, that kind of stuff, I think would add the political pressure in terms of removing some of the obstacles. The third thing that I would say is, countries coming together and trying to find solutions outside of the system completely. Some of us have been working on a proposal that's supported by many in this room and on the panel to try and get countries, this idea of universal jurisdiction was already mentioned by one or two countries, but get them to come together and create a tribunal amongst themselves, basically delegate universal jurisdiction collectively in that sense. So basically what Germany can do on its own and has been, what Argentina has been doing on its own, what Ghana can do on its own, what Japan can do on its own, come together, and at least for the issue of chemical weapons, come together and say what we are exercising collectively, what we are doing individually as an exceptional measures, because a lot of these kind of courts, international courts, are blocked. There are also other ways, such as there is, without getting into the technicalities, there is an argument to be made that the regime engaged in the same forced deportation of people from Syria to Jordan in the same way that Myanmar engaged in that deportation to Bangladesh. And the International Court was happy to explore the crimes committed in Myanmar, although they're not a party, the International Criminal Court. And so we're trying to push for a state referral to try and get a country to say what happened between Syria and Jordan being a party, but that doesn't impact it in any way legally or practically. Therefore, at least on forced deportation from Syria to Jordan, the criminal court could look into what happened there. So there are these avenues that we're kind of constantly exploring on thematic crimes, forced deportation, chemical weapons, and so on. But I think the main barrier is really political, is really showing how this regime is a destabilizing. I know that's one of the points that we're going to get into later, is a destabilizing factor, how the kind of collapse of the rule of law harms the entirety of the region, and so on. And thirdly, or fourthly, I would say that also it's perhaps important to try and keep exploring other avenues. So, for example, there's a group of us that are looking at what can we do criminally from a legal perspective on the issue of Captagon, on the issue of drugs. I know our Syrian American colleagues have been pushing nonstop in terms of getting acts passed on and sanctions passed on the issue of Captagon. But I really think, this is a matter that the US has acted upon when it comes to Venezuela, when it comes to Colombia, using, very sharp teeth when it comes to kind of issuing warrants and arrests and so on. So we need to kind of, awaken that beast in that sense, and say I'm happy to see Moaz nodding to that point, to be able to see that, we need to be able to get the narcotics issue that the regime is kind of sharing across the region and distributing across the region to trigger the criminal accountability path towards narcotics. So we need to come in whichever way we can against this regime. And I think only then the obstacles will start to melt, and people say, actually, let's revert back to the old models, because this ecosystem of us pushing right, left, and center, Syrians are clearly not going to give up. The allies of Syrians are clearly not going to give up. So we need to let's try and go back to a model solution, which might not be ideal, rather than this kind of new innovative ways that are happening. And I think only through that action and offering alternatives and trying to find the next best thing and pushing with that, we can slowly remove those obstacles.
Thank you, Ibrahim, for giving us a number of innovative ideas that can be acted upon in a very concrete manner to bring accountability to bear in the Syrian conflict, and to find a way for the victims to begin to heal and to reconcile. So let me pick up, Ibrahim, on that theme that you developed there at the end, and turn the microphone to Milena Sterio in just a bit, or actually now, to discuss transitional justice and its role in reconciliation. And then we'll turn to Fadel to talk about victims' rights and support for those victims. So Milena, if you could walk us through some of the key components of a comprehensive transitional justice process, how can they be effectively implemented in the context of Syria to promote a lasting, durable peace based upon reconciliation? And what lessons can be drawn from other conflicts or situations designing and implementing transitional mechanisms in Syria? You're ideally positioned to answer this question, since you've been involved in over 24 conflicts, helping them to figure out how to implement transitional justice mechanisms. So Milena, over to you.
Thanks for that question, Paul. So transitional justice is basically a process that's used to address past human rights violations with a view towards the future, to ensure that such violations are not repeated in the future. Transitional justice can focus on accountability, and here we can talk about prosecution. So the first part of our discussion here already focused on prosecutions at the international level, hybrid level, regional level, national level. But transitional justice also focuses on rehabilitation, reconciliation, reparations, victims' rights, disarmament, demobilization, security sector reform, lustration. So basically a broader set of political and societal reforms which might be necessary in order to achieve true reconciliation, in order to make sure that those violations of the past are not repeated in the future. In terms of other countries, other examples of transitional justice, let me mention just 2 examples. Let me talk about a bad one and perhaps a better one. So not a great example of transitional justice is Iraq, where for the most part, transitional justice has been a failure, starting with a very problematic prosecution of Saddam Hussein. At the time, there was a special tribunal for Iraq that had been set up that was basically plagued with all sorts of legal procedural issues, and also ultimately culminated in this botched execution, which definitely undermined the legitimacy of those proceedings. Then we had a failed lustration attempt. There was an attempt to basically de-Ba'athify Iraq, to say that those who were involved with the Ba'athist regime could no longer participate in public and governmental positions. And that was to a large extent a failure. Now, Iraq is obviously a very complex place. There were lots of factors that played into this role. But I think the one thing that we can point to is the fact that in Iraq, the international community was never able to actually engage with the local actors to achieve a broader set of political and societal reforms. Those were never truly implemented, and as a result, transitional justice hasn't really worked. A better example might be Colombia. Now, I know this is geographically very far removed from Syria, but we have seen very, very interesting developments on the transitional justice front in Colombia. So in Colombia, there was a peace agreement that was signed back in 2016. And as part of that peace agreement, which basically negotiated peace between what's now the government and the rebel forces, including the so-called FARC, as part of the peace agreement, there was a transitional body set up called the Special Jurisdiction for Peace. Now, the Special Jurisdiction for Peace is basically a very broad transitional justice mechanism that includes a court, so includes the so-called Court for Peace, which can prosecute offenders of human rights, but it also includes a chamber of recognition of truth and responsibility and determination of facts and conduct. I know that's a mouthful, but that's the English translation of the Spanish term. But basically, it's a truth and reconciliation body. There's also an amnesty and pardon chamber, which can hear testimony from individuals who are applying for amnesty. And then there is an investigative mechanism and also a separate chamber, if you will, that's specifically devoted to victims and reparation for the victims. Now, the mandate of this Special Jurisdiction for Peace is not just prosecutions, but it's also victims' rights, reparations, truth, reconciliation, and also the fact that the jurisdiction itself is set up with the goal to contribute to the achievement of stable and lasting peace. Now, that's the type of broad, comprehensive transitional justice body, transitional justice mechanism that can actually be successful. I would say that the jury is still out when it comes to Colombia. I think it's premature to say whether there has been tremendous success, but at least we have seen the establishment of a body that has a very broad mandate and that has the potential to actually achieve accountability, reparations, reconciliation, and to truly achieve the goals of transitional justice. And so to bring all of this back to Syria, what I would say is that what we need is a combination of not just accountability, and again, we've been having those conversations, but also we would need broader societal political reforms, the establishment of institutions in Syria that are actually able to deal with things like victims' rights, restitution for the victims, return, reintegration, national reconciliation, healing, if we want to truly have a successful transitional justice process take place in Syria.
Thank you, Milena, for walking us through that comparison with Iraq and with Colombia and for giving some very concrete recommendations for establishing a comprehensive transitional justice process for Syria. Let me turn the microphone now to Fadel to get a little more granular and detailed on victims' rights and support for victims and survivors. Fadel, again, compound question. I love these compound questions. What measures are needed to ensure the rights of victims and survivors of atrocities in Syria? How do we ensure that those rights are respected and upheld? How can support services and reparations in particular be provided to victims to address their needs and facilitate their participation in the accountability process, recognizing that they are victims, they are survivors, and they are witnesses, and they need a range of reparations and reconciliation support, as Milena had noted. And what ideas do you have for the role that civil society organizations and local communities can play in advocating for victims' rights and providing those support services? So over to you, Fadel.
Thank you very much. Indeed, we are, first of all, we are working for victims and with them. And we are victim, by the way. Like almost the vast majorities of Syrians are victim. I'm victim, Bakr, Ibrahim, even we are speaking as an expert or whoever, but we are unable to return back to Syria. We are forcibly displaced. So we are victims. More than 14 million Syrian, they cannot be back. 7 inside Syria, 7 outside Syria. If we, and this is for sure violation. I don't want to speak on other violation, but the vast majorities of Syrians also affected by the HLP laws, between two brackets. Those laws violated the human rights law and looting their properties and land. Some of those laws that target, they can affect millions of Syrians. So we need to include the victims in every angle of our work as a human rights organization, because simply, if the victims didn't cooperate, if we don't have a solid and a bright reputation, they will not cooperate with us. What that will lead to this, we are unable to document what is they are facing, what violation they are facing. So they are part of each or from the process of our work. This is our methodology. They are our supporter, and we are working for them at the same time. So the victims also, they have duty, they have responsibility, because they need to be aware about their engagement, how much essential is it. And this is also our responsibility to address that. The third point here, the perpetrator want us to be exhausted, want us to get tired. And I'm keep getting this question. For sure, I'm tired. But what I can do, we have family inside Syria, we have friends who's detained or disappeared. So we need to continue documenting the violation committed against the victims, against our people. The perpetrator want to commit violation, and they don't want anyone to report about it. So all of the perpetrator is fighting us and trying to eliminate and criticize our work. The fourth point, or the fifth, I'm not sure, is providing the moral and financial support. I was at Brussels conference, and we held an event about the lack of humanitarian aid. Unfortunately, this the reducing of aid is targeted also not only the WHO, the announcement, the last year they announced that they reduce the share in all Syria, but also 3 months ago, the UNICEF also halt one of their essential operation in delivering water in many camps in northeast Syria, near to Aleppo. So we advocating. I know that for sure Syria been affected by many conflicts, Ukraine, Gaza, and Sudan, Yemen, but eliminating the aid will generate further violation, including the exploitation against women and children. The children will be forced to join the worst form of child labor, and for sure will generate more refugees. We need those who is inside Syria to, at least not the whole population, to move out of Syria, and Syria will become a failed state. So our duty to keep asking the states to sustain their support. A political message is also key for the victims to hear that the key states will never normalize their relation with the Syrian regime. We are keen to keep organizing international event and bring on board the key states. The things is that in Syria, the civil society, and the second part of your question, Sarah, that is the civil society in Syria is playing a government role, of government functions. I never met with any Syrian organization, and they are playing a civil society role only. They are playing a government role more than I'm talking about the effective organization, not the fake one. So eliminating the fund and targeting those organizations, for sure that will be affected the victim's right and will eliminate those organization functionality toward the victim. Thank you.
Thank you, Fadil. That was very helpful and enlightening on the role that civil society and local communities can play. Keeping an eye on the time that we have, and the clock is reminding us, it's giving us our 3-minute warning. And I know we have a number of senators and representatives coming for lunch. So I'm going to turn the microphone now to Milena for 2.5 minutes to tell us about the future prospects for achieving accountability. And then I'll close with a 15-second thank you and turn the floor back to you, Dr. Bakir.
So on accountability and peace, obviously, it is crucial to keep having these conversations, to keep advocating both here at the US government and also within the international community that there is a need for accountability, that there is a need for peace. On accountability, one body that we touched upon, but that I just wanted to emphasize is the United Nations General Assembly. I think it's important to keep those efforts going in the UN General Assembly to promote accountability. The IIIM that we already mentioned was created through the General Assembly, through really wide support of various countries in the General Assembly. And the reason that the General Assembly is important is because there's no veto power there. So Russia, China, other countries, they cannot veto efforts that enjoy wide support from various other countries, and resolutions can be passed through a simple majority. On the accountability front, we actually have precedent from the General Assembly. The Cambodia Tribunal, which prosecuted leaders of the Khmer Rouge regime, was actually created through an agreement between the government of Cambodia and the UN General Assembly, and it was specifically endorsed by the UN General Assembly. It did not go through the Security Council. So I think it's important to keep advocating for the need for accountability in the General Assembly. On the peace side, we know that so far there have been basically two different initiatives to have peace talks for Syria, the Geneva peace talks, and then also the Astana peace talks. On the Geneva side, we know that those talks have basically stalled. Not much progress has been made since 2018, but there's no reason to simply abandon those. I think there's a need to, reinvigorate those talks, return to Geneva, to come back to the negotiating table. The Astana talks have been initiated by Russia and led by Russia, have actually resulted in the creation of 4 different de-escalation zones. We know that those ceasefires haven't necessarily continued, but we have seen some progress on that front. I'm obviously not advocating in favor of anything led by Russia, but I do think it's important. I do think it's important to keep advocating for the need for peace in the international community. And so I am an optimist by nature. I do believe that if we continue to talk about the need for accountability, if we continue to promote the need for peace, the need for negotiations, I do believe that we will see developments on the international side in the near future.
Thank you. Well, I just want to thank Fadil, Ibrahim, and Milena. It's been a real honor and a privilege to have them join the panel and to share their thoughts and insights on holding those perpetrators of atrocity crimes to account and the role that plays in building a durable peace. And I'm very grateful for Dr. Bakir, Jude, and the team and the board of the Center for Secure and Safe America for hosting this important conversation and launching this annual conference again. Thank you.
Thank you for having me. All the best. Thank you.
Thank you so much, Professor Williams, Professor Sterio, and the esteemed guests for your insightful session here.